Today, my groupmates and I, ADRIANA, AINA, and ADRIANA, will present about discharge and remedies of the contract.
Discharge of contract. Contract is terminated and contracting parties are free from further obligation arising from it. In discharge by performance, we have time of performance, place of performance, reciprocal of promises, contingent contracts, tender of performance, personal performance, and joint agreements. Reciprocal promises. In Section 52, promises which form the consideration or part of the consideration for each other are called reciprocal promises. When reciprocal promises have to be simultaneously performed, the promiser is not bound to perform unless the promiser is ready and willing to perform his promise. In Central Malaysia Development Ltd versus Chin Park Chin, the defendant under an agreement was to execute a valid transfer and deliver a vacant position of a piece of land to the plaintiff. Upon the latter paying the agreed deposit, it was held by the court that the plaintiff was entitled to repudiate the contract and recover the deposit, since the defendant had failed to deliver vacant. Contingent contract. Section 32 provides these are contract to do or not to do something depending on some event. Collateral to contract does or does not happen. In Section 33, a contingent contract cannot be enforced until the happening of an event stipulated in the contract if contract is contingent upon the happening of a certain event. However, if a contract is contingent upon a certain event not happening, it can be enforced when the event becomes impossible. Tender of performance. Section 38(1) provides in order to be discharged of their contractual obligation, the parties must perform or offer to perform the respective obligation. Where one party has made an offer to perform his obligation exactly under the contract and was rejected by the other, the former will be free of his obligation. The tender of performance must fulfill the condition like it was unconditional and it was made at the proper time and place. Personal performance. In Section 41, whether or not the parties to a contract are required to personally perform their respective obligation depended on their intention at the time the contract was made. This principle was applied by the Federal Court in Latham Semel versus Nam Ong Housing Sdn Bhd, where it held that the contract had to be performed by the applicant personally. Where the performance of a contract is dependent on the personal skill of the promiser, it is implied that they must perform the contract personally. Joint agreements. Where two or more persons have made a promise under a contract, they are said to be jointly and severally liable under the contract. In Section 44(1), the promiser are jointly liable. The promise may compel one or more of the joint promisers to perform the whole of the promise. Section 44(2) provides that if only one of the promiser was waived and he has made full payment to the promise, the promiser concerned can claim from the other promiser for their share of liability. Section 44(3) further provides that the other joint promisers must bear in equal share the loss arising from the default. A release of one of the joint promiser from liability by the promise will not free the other joint promisers. The released joint promiser is not released from responsibility to the other joint promisers.
Next is discharge of contract by agreement. Discharge by agreements mean contract may be discharged by agreement when parties to the contract agrees under free consent to discharge obligations from the former contract. A contract can also be discharged if the parties agrees that the contract will be discharged. The agreement can be made during the contract or after the contract has been made. For example, Siti entered into a contract with Hani. In the contract, both agreed that the contract will be discharged if the profit of the business is less than 400,000 ringgit in a year. If the profit is less than the contract is said to be discharged by agreement. There are two types of discharge as you can see in this slide, which is Section 63 and Section 64 of Contract Act. Under Section 63 of Contract Act provides that if the parties to a contract agree to substitute a new contract for innovation or to rescind or alter it, the original contract need not to be performed, while under Section 64 of the Contract Act provides that every promise may dispense with or remit wholly or in part the performance of the promise made to him, or may extend the time for such performance, or may accept instead of it any satisfaction which he thinks fit. Next is discharge by breach. Discharge by breach under Section 40 provides that when one party to a contract is in breach of the contract, the other party to the contract has right to rescind the contract and claim the damages from the breach. We can relate this with the case of Chu Yin Lu versus Viswalingam Pillai. The court allows a contract to be rescinded when an employer fails to pay wages once in every 2 weeks, as promised. A breach may be met expressly or impliedly for one's conduct. However, contract can put to an end if a party to the contract did not want what they have promised in the contract. There are reasons why breach may occur. The first one is because refusal to perform it. It happens when one party informs the other by conduct or words that he does not want to go on with the contract, and the former party is said to repudiate the contract. Second is because the disability to perform it. It happens if one party is disabled to perform, so the contract is discharged if the disability is because of something beyond the control of the parties. It does not amount to a breach of contract, but is discharged through frustration. Also, breach can either be an anticipatory breach or an actual breach. Anticipatory breach occurs when one party indicates before the time of the performance to either he does not intend to perform or he intends performance, different from the set out in the contract. And the nonsense party can either repudiate their contractual obligation as soon as the other party indicates their refusal to perform, or wait for the performance date and hope that the other party perform their duties. Actual breach occurs when performance is due on or in the course of performance. It can be either a failure to tender any form of performance inadequate. The last one is discharge by frustration. Discharge by frustration means that the contract is terminated if the things that the parties agree to do is impossible to perform. And it can be at the time the contract was made or when the contract has been made. The obligation became impossible to perform. Under Section 57 of the Contract Act, distinguished that there are two types of impossibility. First, the performance of which is impossible at the time it was made, which an agreement to do an impossible act, such as contract, are void. The second one is a contract, the performance of which had become impossible or unlawful after it was made due to some event the promiser could not prevent. The contract is said to have been frustrated, which refers to the doctrine of frustration, and it becomes void. In order for a contract to be frustrated, the qualification must be satisfied. First, the event that caused the frustration must not be self-induced. For example, not caused by the parties themselves, it must be something beyond their control and not foreseeable by them. Under Section 57(2) in the supervening event must be something that the promiser could not prevent. In the case of Yi Seng Plantation Sendirian Berhad versus Kerajaan Negeri Terengganu and Ors, the court held that the refusal of the State Executive Council to alienate the land was as a result of the deliberate act of non-compliance of the consent order by the party. It was not supervening act. According to the court, self-induced frustration is not frustration. Second is the performance of the contract must have impossible and not merely more difficult or more expensive. Also, the event that occurred had caused a fundamental or radical changes in the circumstances so as to make the performance of the contract something radically different from originally undertaken. And the last one is the frustrating event has substantially prevented the performance of the contract as a whole.
Okay, next we move into next part, which is remedies for breach of contract. But first of all, what is remedies? Remedies is a right that can be claimed by a party that experienced losses because the other party was in breach. Okay, next we look into remedies. Remedies was divided into four. First of all is damages. Second is specific performance. Next is injunction, and lastly is quantum merit. Okay, for damages also divided into two, which is substantial, nominal, and exemplary. For substantial is a reward to put plenty in a place if dependent perform a contractual obligation. Next is nominal. Nominal is a small reward to penalty after show that there is a breach, unless there is exemplary. Exemplary is a reward given is far higher than the losses incurred. Okay, the next part for remedies is specific performance, injunction, and quantum merit. For specific performance is actual damages cannot be ascertained or be adequately relieved by money. And we move into the injunction. What is injunction? Injunction is discretionary given by court under Section 15, Specific Relief Act. And lastly is quantum merit. Quantum merit is a claim that can be made by a plaintiff who has performed obligation of the contract. I think that's all for the remedies. Okay, we decided to end our presentation.